I'm Jeb Butler, and this is Tom Giannotti of the Butler Kahn law firm. Today we'll talk about a negligent security shooting case that occurred at an apartment complex in DeKalb County. We ended up being able to settle the case on our client's behalf for $1.5 million. And Tom's going to walk us through kind of the basics of the case.
Yeah, so this was a case where our client was the victim of an armed robbery at his apartment complex. He was shot in the course of that armed robbery and thankfully survived, but he had a rough couple months of being in the hospital and a long road to recovery. And this really was a case where we call negligent security cases, where you have an apartment complex where the management advertises security but doesn't actually live up to those promises. You see behind us here we have a photo of the access gate to the property, and there's actually a sign even that says that all the activities are monitored by a video camera. That just wasn't the case.
There wasn't a video camera.
Yeah. So, and then same with this. This is like supposed to be a guard shack. There is no security patrols, no security guards whatsoever.
Well, how about the gate?
Yeah, I mean, as you can see, the gate's wadded, and this is how it was all the time. This is not just for this photo. That's how it was on the date in question. Management even assured the residents that they would fix this gate, and even made the residents pay the money for key cards. They never actually delivered those key cards. So just some management failures, and also the last thing I'll talk about on this point is this is a video here. You can see
This is like the back of the property?
Yeah, so this is actually one of the buildings, apartment buildings on the property, and incidentally, this is actually where we believe that the assailants were able to escape the property without getting caught by police. You can see.
So there's like there's like a fence around the property, and then the gate that stands open. But the fence is at least supposed to keep people from coming in, like the backside. Is that fair?
Right. I mean, fences are there for a reason. So, you know, this when they are maintained properly. But you can see here, this is somebody that's using this as a cut through. There's even a visible footpath where people use this broken fence to get in and out from this. This is another apartment complex next door.
So there's here's the break in the fence where the guy came through, huh?
Yep, and that was pulled back, and you know, not a very secure location for that reason as well.
So it could be where people came in, and it could also be where the gunman escaped in our case, huh?
Right.
Okay. So, you know, in every case like this, we face some challenges. And one of the challenges we faced here is that the apartment complex and their management company tried to blame our client. They claimed that this shooting wasn't one in which our client was innocent, but instead it was a drug deal gone bad. And the manager of the apartment complex, or one of their employees, claimed to have like overheard something about that. Overheard someone say this was actually a drug deal gone bad. So Tom tracked down the witness. Well, we believe in witness work. We went and found the person who allegedly made that statement and said, "Hey, did you say this?" And they were like, "Absolutely not. I never said anything like that." So we felt like by tracking down that person and some other witnesses, we had built a solid case that would look good at trial if it came to that.
Yeah, and of course, I'm sure people are familiar with hearsay. I mean, it's hearsay to say that, well, I heard somebody else say this. Mm-hmm. At trial, that witness would have to come to court and say that himself. And of course, that witness is, he would never testify to that. It's not true. So we didn't think that was just a very good defense at all.
We had another challenge with what's called invitee status. Tell us about that.
That's right. So in order to recover under Georgia's premises liability statute, in other words, in order for a property owner like a management company to owe a legal duty to that person to keep the premises reasonably safe, that person has to be what we call an invitee. And that, in this case, it just means that there's some kind of a business relationship, kind of monetary benefit, like exchanging money for rent. And so in this case, the apartment management company argued that. Well, they pointed out correctly that our client was not on the lease, but they argued, we think incorrectly, that this is actually the portion of the lease, and you can see the highlighted part. Nobody else may occupy the apartment who's not listed here. There's nobody listed. I've blocked it out to protect our client's privacy, but this was our client's girlfriend on the lease, actually. So he wasn't on the lease.
And that could be a problem for us, but
number one, he's not a party to the contract, and generally, if you haven't signed a contract, you're a stranger to the contract. You're not bound by the terms. And more importantly, the evidence in this case showed that the apartment management company just wasn't strictly following these lease terms. There was evidence that our client had greeted the property manager by name. They were on a first name basis and saw each other regularly on the property, and even had conversations about our client's dog living at the apartment. So the evidence was clear that they knew he was living there and allowed it anyway, despite what the lease may have said. So we thought for that reason as well, it just wasn't a very good defense. And ultimately, when our client decided that he was going to extend a settlement offer, ultimately they did recognize that we did have a strong case, although there was a bit of a hiccup. I think, Joe, we can talk about that first. We initially sent a settlement offer for less.
Yeah, that's right. So initially we'd been told by the defense that the limits of coverage, that is the entirety of the liability insurance carried by the property, was $1 million. So we talked with our client and decided to make an offer in that amount. But as a condition of accepting the offer, that is, in order to end the case, the insurance company had to testify in writing that $1 million was all the coverage there was. And as soon as we made that a requirement, whoa, they had to stop us and say, well, actually, there's more insurance. So we went back to our client, talked about what to do, and made a demand for $1.5 million, and that is what was accepted. So the case settled for 1.5 as opposed to 1 because we caught them holding back insurance.